Speaker this morning is Fiona de Londras. Fiona is the Professor of Global Legal Studies at the University of Birmingham, focusing in her work on complex policy areas affecting human rights, counter-terrorism, human rights adjudication at the supranational level, and abortion law reform in Ireland. And her new book, Repealing the Eighth, Reforming Irish Abortion Law, co-authored with Mairead Enright, will be published in early 2018, and there's flyers for that publication available. I think it's important to acknowledge that Fiona is a representative of the best tradition of academics working in the public space and engaging with public policy in a very active way. And of course, even more significantly, Fiona is from Cork. Well, she spent her formative years intellectually in Cork, which is even more important. Fiona de Londras.
Thanks, everyone. Liam's point there reminds me of the day that I went to the Oireachtas Committee a few weeks ago, and John McGurk on Twitter said, "Did they have to go all the way to Birmingham to get somebody to talk about Irish abortion law?" And someone said, "John, Fiona's from Ireland." And he said, I know her well, she's from Cork." And I said, I'm not. Anyway, so I've been asked for about 15 minutes or so to talk about abortion law in Ireland, and this will be familiar to many of you, but to some of you less so. And the health warning ab initio is that it is definitely not pleasant listening. So quite in contrast to everything Francis was saying about how international human rights law regards fetal personhood, that is, or the fetus, that is, as an entity in relation to which we could ascribe some value, but one that does not hold rights in a legal sense, the Irish Constitution specifically says that the unborn life, and that's the phrase that's used, is a rights bearer. In particular, in Article 40.33, that is the Eighth Amendment, it recognises a right to life of the unborn that it establishes as being equal to the right to life of what they call the mother, and it requires the state to vindicate that right to the extent that is practicable. And effectively, the Eighth Amendment has become the conduit through which all questions, not only about termination of pregnancy, but also about personal rights during pregnancy, have been considered since its introduction in the early 1980s. Now, it took quite a long time, until 2013, to actually get a piece of legislation that told us what the Eighth Amendment meant in practical terms. And that piece of legislation is the Protection of Life During Pregnancy Act of 2013. And that act provides, more or less in contradistinction to almost everything that international human rights law would say, that abortion is only available where there is what is known idiosyncratically in Irish law as a real and substantial risk to the life rather than the health of the pregnant person. Now, real and substantial risk, problem number one is the very limited access. Problem number two is that real and substantial risk is not a medically meaningful term. It produces uncertainty within practice because it is difficult for practitioners to know when a risk has reached A, the standard of being a risk to life rather than a severe risk to health, and B, when the risk to life is serious enough to intervene in order to bring a pregnancy to an end. So one of the products of this law is not only that uncertainty in practice, but also that in some cases it will force medical practitioners to proceed with a course of treatment that, in their view, is not in the best interests of their patients, does not maximise their patients' health outcomes, and in fact requires them to wait until you have reached a level of severity that may be irrevocable in terms of the health of the pregnant person before you can intervene at all. Part of the difficulty that results from that, of course, relates to delay. Because the threshold is so high before somebody can access abortion care, it is quite possible that a delay is built in either from good faith or from bad faith, or from good practice or from bad practice in medical treatment. And that is particularly important in this context because the right to termination of pregnancy in Ireland, even under the 8th Amendment and even in the limited circumstance where there is a risk to life, is not a right to abortion properly called. It is a right to bring a pregnancy to an end. So that if the fetus has reached viability, again an undefined term, but it will, in medical practice they determine viability on a fairly quotidian basis. If the fetus has reached viability, the statutory mechanism of bringing the pregnancy to an end is in fact early delivery rather than abortion. So I hear Francis's point about the terminology termination of pregnancy, but in fact in Ireland it is quite important that we talk about abortion, access to abortion as a mechanism of bringing a pregnancy to an end. I see Alva Smith there recall in 1992 during the referendum the government kept talking about the substantive issue, and at some point she said people do not go to England for a substantive issue, they go to England for an abortion. So it's very important that we use that term actually and that we get it used in law as well. As well as these, and by the way, the risk to life that will qualify one to access abortion care can either be a risk that emanates from a physical condition or it can be a risk of suicide. But even though the Constitution does not distinguish between those two things as a basis for accessing abortion care, the legislation does. It is, there are different procedures. It is practically twice as hard to access abortion care where the risk to life is a risk of suicide, not least because the pregnant person may have to engage with up to 6 practitioners plus their GP before they will actually get be determined that they can access abortion care. And in a country where we have very, very, very few people specialised in perinatal psychology, that produces delay as well. So it's an extremely oppressive statutory framework. Now, pregnant people in Ireland who want to access abortion care, but who do not fall within the very limited circumstances outlined in the 2013 Act, do have a right not to be prevented from travelling, not a positive right to travel, a right not to be prevented from travelling to access abortion care abroad, but there is no material or other support provided by the state to enable people to travel, to exercise their right to access abortion care. So the Constitution has structured a tolerance for abortion travel into it, but because there is a right, this right around travel, but the state does not enable people to access or exercise that right in any meaningful way. The support there comes largely from activist groups who support people materially and otherwise with travelling to access abortion. There is also a right to information, but that right is heavily restricted, highly conditioned by the fetal right to life. So under the 1995 information bracket, access to services for the termination of pregnancy outside the state, close bracket, again we don't say abortion, Act 1995, no directive information about abortion can ever be provided, but there is not necessarily a prohibition on providing directive counselling for options other than accessing abortion. Medical practitioners and their employees are not permitted to facilitate access to abortion care abroad. So even in the most complex medical situation, a doctor in this country cannot refer her patient to a doctor in another country for abortion care. That patient has to go and sort it out for herself, and then their doctor might photocopy their medical files for them and hand them to her, and she then ships up in Liverpool usually with her medical files to try to access abortion care. It is a criminal offence for a practitioner to refer someone for abortion care outside the jurisdiction. So we have this very heavily conditioned situation where there is high potential for delay, high levels of uncertainty, even within this very narrow ground that permits of access to abortion. And all of this really stems from the equivalence that is produced by the 8th Amendment between the constitutional right to life of the fetus and the constitutional right of the pregnant person. And that is reflected in the use of the word mother in Article 40.33. Because effectively, from the moment that one becomes pregnant in Ireland, one becomes constitutionally a mother, and one's other personal constitutional rights are suppressed in a way in order to prioritise and protect the fetal right to life, which could also be simply described as a fetal life to be born alive, because the law also does not attend to questions around quality of life or the length of life once the fetus is born. And I'll come back to that in a second. So what we see here is the 8th Amendment, which in itself is part of a complex architecture of oppression of women and of women's sexuality in Ireland, and which then subsequently produces more complexity in that architecture. It is relevant not only to access to abortion, which is what I'll focus on here, but also to personal rights in pregnancy more broadly. So that for many women in Ireland, pregnancy is experienced not as an emancipatory or a joyful experience, but as one that is littered with physical and bodily intrusion and oppression, because your right to consent or to refuse consent to medical care is conditioned by the constitutional right to life of the fetus. And in fact, the guidance from the Health Service Executive is that if a practitioner is not clear about whether or not a woman's refusal of consent for a medical treatment that is proposed to her might impact on fetal life, they may have to go to the High Court for a determination of whether she is entitled to refuse consent to care. Ordinarily, remember, we are entitled to refuse consent to medical care. So that's I warned you it was pretty grim, right? So that's the status quo. Within that status quo, I want to mention 4 areas of uncertainty that are significant, because there are still some things we don't even know about how that regime works in a jurisprudential sense. The first is that there is no definition of the unborn for constitutional reasons. So the Protection of Life During Pregnancy Act does give us a statutory definition of the unborn, which is effectively everything from implantation to birth. And the suggestion from a case called Roach and Roach, which was not about abortion, is also that it's from implantation. But in fact, we don't have a definitive answer from a court about what the unborn is under the 8th Amendment. And it is, I find it amazing that we haven't yet had a significant challenge to something like emergency contraception, because there is clearly some grey area there. Secondly, we do not know under the Constitution whether it would be permissible to allow for abortion in cases of what is sometimes known as fatal fetal abnormality. The government, successive governments feel that it would not be constitutional, and there are good arguments in support of that position. Most strongly, if we consider that the pregnant person's right to life is a right not to be dead, and that fatal fetal abnormalities do not impact on your right not to be dead, okay? But the strong argument against is, first of all, that the state is not required to do anything that is futile to protect fetal life, so that if fetal death is inevitable, they should be able to engage. And secondly, that the right to life does not need to be so narrowly constrained or defined as to be a right not to die, so that it could be more richly defined. But in any case, in the absence of any court case about this, we don't actually know whether abortion would be constitutionally permissible in cases of fatal fetal abnormality or not. The third source of uncertainty is we don't actually know what rights the fetus has. We know that it has a right to be born, because that is written down in Article 40.33. But before the 8th Amendment, there were some suggestions by a number of judges that there might be fetal rights as unenumerated rights in the Constitution. We don't know what the scope of those would be. We don't know the legal force of those observations. And we don't know if we repealed the 8th Amendment, those rights would still exist. And we also don't know how broad the constitutional rights are now. There are conflicting High Court decisions, some saying it's just a right to life, and some saying that it is all the rights that a born child has under the Constitution. And there's an appeal before the Supreme Court to try and figure out which one of those it is. Interestingly, when the prospect of rights for the unborn appears to interfere with the potential of deportation, the state is interested in figuring out what the scope of those rights might be. And fourthly, we do not know the full scope of personal rights during pregnancy. So in the ordinary course of events, pregnant people, like other people, have a range of constitutional rights. Francis mentioned some of them: bodily integrity, privacy, the right to be free from torture, inhuman and degrading treatment or punishment, the right to life, and the right to equality. But in the course of pregnancy, all rights decisions seem to be funneled through the Eighth Amendment. So there has been stasis in the jurisprudential development of those constitutional rights in the context of pregnancy. And so if the Eighth Amendment were to be repealed, a big piece of work would need to be done on trying to figure out what the scope and scale and depth of those rights might be in pregnancy, if it differs to how those rights operate outside of a pregnancy situation. So there's a large amount of uncertainty there. And so as we come to the point where it looks like there will be a referendum, and it looks likely that the referendum may be a simple repeal referendum, which would be the wisest approach, we have to start thinking about what should underpin the way that we think about rebuilding our constitutional approach and our legal approach and disposition towards pregnancy, towards reproductive autonomy, and towards rights, including the right to terminate a pregnancy. And much of this ground has been covered already by Francis, so I'll go very quickly through it. The first thing that we must do is to recenter pregnant people in our legal treatment of pregnancy. In other words, to produce a body of law and practice that recognises the autonomy, agency and rights of pregnant people. What the Eighth Amendment effectively does is to say the decision about whether or not to remain pregnant is so complicated that we will relieve women of the burden of making it by making it for them. Right? That's the basic product of a provision like the Eighth Amendment. And what that does is it ignores the fact that every day women make complex, interpersonal, embedded, ethical decisions about our reproductive lives. Those decisions might be to take a pill every morning so that you try to ensure you don't get pregnant. They might be to end a pregnancy, and they might be to continue a pregnancy. But all of those decisions are ethical decisions, and they are often hard decisions. And what we know about hard decisions is that often there is no right answer. There is a series of potential answers which are more or less on a par with one another, and that what matters is that we grab that opportunity and exercise our agency in determining our own life courses. And the Eighth Amendment prevents women from doing that. So to restructure that, to make the socio-cultural shift that we need to really move away from the cultures of the Eighth Amendment, means we have to recenter rights, agency and autonomy for pregnant people. We also, secondly, need to de-exceptionalise abortion. Irish politicians seem to think that abortion is a uniquely difficult, uniquely complex area of policy making. It's not. It's often a very difficult area of personal decision making, but it's not a difficult area of law and policy making. And there is acres of good practice internationally that will help us to make those decisions. It is nonsensical for people who every year make decisions about, for example, whether or not somebody who cannot work will have enough money to feed themselves, to say that there is something uniquely complicated about whether or not pregnant people should be able to make decisions about their own reproductive lives. Politicians make what we might call life and death decisions every day, but the Eighth Amendment has allowed them to mythologise abortion as something that they could not possibly consign to the ordinary pages of politics. And it's important that we break that. And the final point is that it's important that we do not fetishise legal certainty. I've already shown that there is plenty of uncertainty in the current law, and of course legal certainty is desirable. But legal certainty should not just be about whether or not doctors know what they can do. It should be about whether or not the law is accessible, stable, predictable, and usable by pregnant people. So we have to first of all forget that we might be able to achieve absolute certainty. That is a futile quest. And if we try to pursue it, we may easily find ourselves with a new constitutional provision that is just as complicated, just as unusable, just as oppressive, just as harmful as the Eighth Amendment, and instead to produce certainty in the ordinary way through clear, well-crafted legislation, practical guidelines and protocols for medical practitioners, good, clear, unbiased information for pregnant people, and a proper system of sex education and reproductive justice for all. Sounds simple. That's it.
Thank you, Fiona.